Good morning to you.
Good morning, Senna.
First, I want to ask whether that statement raises some questions for you.
Yes, I wasn't listening to your program. I don't even have network here.
Okay,
I'm far away in Huawei.
but I guess you've seen a statement from the Attorney General.
I cited it this dawn, and I think it's a novelty to me, where for the first time, Attorney General exercising the powers under the law issues a nolle prosequi to terminate the process of prosecution, goes ahead to give such an elaborate reasons or rationale behind the exercise of that discretion is a novelty to me. You know, Attorney General has never given reason for entering a nolle prosequi because it's as of right, it's a legal right available to the state in criminal cases. So I commend the Attorney General highly for this novelty. It is in keeping with the President's promise to govern the country with openness and accountability to the people. Now, the reasons I have cited, among others, state that a threshold was given by the Attorney General for termination of such cases, namely that 60% of the alleged indebtedness is satisfied. In other words, the recovery of a minimum of 60% of the debt in question, and that the Attorney General and the state have satisfied themselves that that threshold had been met by the accused persons.
I know you said okay. So, what do you make of this whole policy direction that the Attorney General is now pursuing to say if we can recover up to 60%, we can decide not to go ahead with the case?
I think that the state must exercise the powers of governance that brings maximum benefit to the generality of all of us, not just to embark on prosecution or the conduct of cases for mere expediency or political reasons. At the end of the day, the state must be asking itself, what is in it for me? What is the end that we want to achieve? In this whole Dr. Duffuor prosecution and others like Ametefe and co, was the previous government pursuing a proper prosecution or engaging a knee-jerk reaction to public sentiments as a result of the backlash that arose after the ill-conceived process of liquidation of most of those financial institutions. To date, most Ghanaians still agree that the previous government did not carry out the proper financial sector cleanup as they purport to christen the whole process. In the case of Unibank and others, what was their offense? That a bank or financial institution supervised and regulated by the central bank suffered some kind of impairment of its capital and thereby require what they call liquidity support, which was rightly within the powers of Bank of Ghana as a central bank, a lender of last resort, to come in to assist such ailing financial institutions with the sole purpose of keeping business afloat, create wealth, create jobs for the mass teeming youth and unemployed people. Remember that the collapse of these financial institutions created a lot of problems that culminated in the financial challenges of the state. Nobody gained from that exercise. It has all been negative repercussions. Banks were closed down. Depositors and investors lost all their investment. People lost their jobs and are unemployed. The state lost revenue through taxes and other revenue. And if a bank, having the right so to do, approaches the central bank as a lender of last resort and borrows money, even if it is true that such borrowed money was misapplied, why should that be a criminal offense? Is it not a debt? In my candid view, those criminal charges were themselves not well properly thought through. So now you and I know that in commercial transactions, such as you and I walking into any financial institution to borrow money for whatever purpose, if we misapply the money, it may not constitute criminal offense. It's simply a breach of contract. It's a debt we must pay. And the state ought to have taken the appropriate steps to collect those debts owed Bank of Ghana, and not to just prepare Trump Act charges to satisfy what we call it political expediency of the government of the day, when government started receiving what we call it the backlash of a program that many thought was what we call it a political vendetta against some of those financial institutions and nothing more. So Attorney General will have to weigh the options and see what exactly the state wanted. Is it the incarceration of those persons who owe Bank of Ghana money lent or borrowed and not recovered, or to take steps to recover as much of that money as could be recovered? If the Attorney General is satisfied that the alternative of collecting as much as the state could collect, rather than pursuing a criminal prosecution whose end is to incarcerate someone who will become a burden on the state again to be taken care of in prison, such a needless exercise, the option to collect such debts, I think, is one that is in the right direction.
So you're saying that in your view, you think that Attorney General is treating what has been the subject of the prosecution as a debt that must be recovered?
Exactly so. And in my view, those actions from Atuesian and so on and so forth, that they took the liquidity support and diverted into whatever. If I go to ADB and my proposal was to borrow money to go into farming, and I use it to go and marry more wives, what is their concern? Is that a crime? I misapplied the money. Simple. And I owe. The bank must take steps to collect its debts in a civil action. The Attorney General ought to have instituted civil proceedings to recover debt, but this indebtedness was made to look like a crime. Those trials were needless in the first place. That is my observation. Attorney General may not have given this as a reason, but insofar as the end of that prosecution is to collect debt and then impose criminal sanctions in addition, I'm of the view that civil proceedings ought to have been the option in the first place.
Quite quite interesting. But where the, because this was initiated by the past administration, where the state feels that your actions endangered the savings of others, that under the financial law you are supposed to hold some of these things in trust for people, that where you giving money to you endangered the savings of others, can they bring a criminal offense against, a criminal charge against you,
Let me
that you
tell you,
breached the law of trust?
you see that even in ordinary private cases, individuals who are owed money, rather than seeing lawyers to have a debt recovery action purely in a civil matter, they go to the police. And the police invite you on a very good Friday morning. You are locked up to spend the weekend just to pay debt. They can easily make civil matters look criminal. It's very easy because the line between criminal cases and civil cases is a very thin one. That same individual debt recovery action could be turned to be a crime of defrauding by false pretenses, because the police will simply frame up charges along those lines to say that you misrepresented a fact of the existence of something, that as a result of that you procured the consent of that complainant who parted with money and you failed to pay. It's the same thing that the state did in this Duffuor matter. They can find the criminal offenses on the statute books given a particular fact and do as they wish. I, from day one, indicated that those cases were nothing but political persecution. They were purely debt recovery cases.
And I'll come back to that, because recently there's been a campaign for, is it pardon to be granted to Mr. Ametefe, and I'll come back to that. But in the meantime, can we not ask the question about how the state arrived at 60% and not more?
Well, if you are owed money and it appears clearly that the debtor is struggling even to survive, and you are most likely to forfeit your money, and you can have something out of nothing, is half a loaf not better than none?
Half a loaf better than none.
Yes. So that is what the state is engaging. If we can collect as much as 60% of what we are not likely to have at all, if we continue the criminal prosecution and go and damn somebody in jail, we are not likely to have anything, and we can take steps to recover as much as 60%. It makes sense.
Well, considering the fact that a court actually agreed with the state when they brought this same circumstances before a judge and actually found somebody guilty, I think they jailed him for 15 years. That's
what has the state gained out of that incarceration in a purely debt recovery matter? It is just to prove a point, because there have been so much noise made about the ill-conceived, poorly planned, and poorly executed policy of banking sector cleanup, which some of us still maintain was a personal vendetta directed at certain financial institutions that the government of the day and those interested in that sector found to be persons that were not on their side. those companies or businesses were deliberately collapsed to satisfy somebody's interest in that sector. It's about dominance, economic dominance and control of the financial sector by somebody or some persons in government at the time.
There are those who feel that this kind of view, if applied to all matters of monies that have been misappropriated or matters of corruption involving large sums of money, will encourage people to be more corrupt.
If you look at the Attorney General's statement, the point was made clear that the step taken by the Attorney General was not intended to give cover for wrongdoing that is so palpable. In other words, the Attorney General is not in any way suggesting that there was no wrongdoing or to give a kind of open clemency to everybody, and that cases will be looked at on their particular facts. And this particular case will not be used as a basis to apply to all others where the factual circumstances will be different. Attorney General, I think, made that point clear.
Let me conclude with you on this note. I was just referring to Mr. Ametefe and the pursuit of pardon for him. This having happened, should that strengthen the case of those who are pushing for that pardon for him, that the president should grant him pardon, and that pardon can be granted under the circumstances where we are saying, we have granted you pardon, but you have to pay this portion of the money?
Well, I thought that this pardon ought to have been carried to the highest during the regime of the previous government. But the exercise of pardon is a constitutional power vested in the president, and the president at his discretion at any time could do so in various circumstances and applicable to all prisoners. I will have no difficulty if that is done. Remember that Mr. Ayine'S took advantage of the Plea Bargaining Act and made several proposals to pay the debt, and it was as a result of his failure or inability to satisfy those conditions that eventually led to his incarceration. If the pardon granted him will enable him come out as a free man to take steps to pay those debts, the state gains better than keeping him incarcerated. We don't gain anything if Mr. Ayine'S remains in prison. If he comes out and he will be able to take steps to pay his debt to the state, I think it makes sense.
But clearly, you're also saying the indication you get from the Attorney General is that this will be applied on a case-by-case basis?
That is so. That is so. There's no blanket statement contained in the reasons given by the Attorney General in the notice of the nolle prosequi.
Thank you. Thank you very much for speaking to us.
You're welcome, Senator.
Lawyer David Ametefe is a private legal practitioner. Join us as always for a quick discussion on this matter of the Attorney General actually deciding. And the statement is what we've been showing that on the screen. Alaska, please put that back. The statement issued by the Attorney General's office. There are many questions that have been asked. Most interesting article was an article written by Professor Kuku Asare, who writes on his page